Welcome back to the channel U.S. Immigration News. We hope you are doing great. In today's video, we'll be talking about Section 245K of the Immigration and Nationality Act, INA, and whether it is possible to get an employment-based green card after working without authorization. The video discusses Section 245K of the Immigration and Nationality Act, INA, and whether it is possible to obtain an employment-based green card after working without authorization. Generally, aliens who do not have lawful immigration status or have violated their status are not eligible for a green card. However, Section 245K provides an exception for employment-based green card applicants who have violated their status for a limited period, up to 180 days. The 245K forgiveness does not apply to all immigration violations and is limited to certain employment-based green card categories. USCIS interprets the 180-day period as referring to the total of all three types of violations combined, and unauthorized employment counted before and after the I-485 filing is included. It is important to note that the 245K forgiveness does not mean that working without authorization is allowed, and other consequences such as removal or deportation may still apply. To get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for upcoming episodes. Without any further delay, let's jump into the video. The general rule. As a general rule, an alien cannot adjust status for certain immigration-related violations. Aliens who do not have lawful immigration status on the filing date of the Form I-485 green card application, or who have not maintained lawful immigration status since entering the United States are generally not eligible to file the I-485 and get a green card. In addition, individuals in unauthorized employment are also not eligible to apply for or obtain their green card. The 245K exception. However, Section 245K of the INA provides a useful exception to these general rules for those who may have violated their status for a limited period. The 245K forgiveness allows for green card approval in most employment-based green card categories even if the applicant has been out of status, worked without authorization, or otherwise violated the terms and conditions of their admission, if the total period of said violations does not exceed 180 days. Limitations of the 245K. The 245K does not forgive all immigration violations such as entry without inspection. However, the 245K can be a useful outlet for applicants who have short periods of violations. The 245K is only limited to employment-based green card applicants. The 245K only applies to EB1, EB2 and certain EB3 cases, and some EV4 cases. The primary beneficiary and all dependent family members can take advantage of this provision, although it is not available in family cases. In the case of asylum seekers, the spouse and minor children of the main applicant can benefit from this measure if they fit the EV category. Filing requirements. No additional forms are required to use the 245K provisions and there is no additional filing fee. Usually, it is not even necessary to explain that this provision is being used, although eligibility sometimes has to be argued. USCIS Interpretation. The U.S. Citizenship and Immigration Services, USCIS, published a note in July 2008 interpreting the provisions of Section 245K. This note addresses how violations are counted and aggregated, stating that only violations occurred after the most recent lawful admission to the United States counts against the 180-day period for 245K purposes. Re-entry based on parole does not reset the clock for 245K purposes. Such entries are not considered admissions as that term is used in immigration law. Full-time employment. It is important to note that instead of allowing up to 180 days of violation, USCIS interprets the 180-day period as referring to the total of all three types of violations combined. Unauthorized employment counted before and after I-485 filing is included. Filing a green card application does not authorize employment, nor does it stop the 245K clock. If an EB3 candidate continues unauthorized employment after filing the green card application, the candidate will continue to accrue days of unauthorized employment. These days are counted against the forgiveness period granted by the 245K. For example, if you work without authorization for 100 days before filing Form I-485, and continue working without authorization for the next 81 days without receiving a valid employment authorization document, EAD, you will not be eligible for 245K. If an employee works only 4 hours a day, 5 days a week during the month of December, all 31 days of the month, including weekends and holidays, will count toward the 180-day limit. Conclusion. This does not mean that you can work without authorization. All other essentials provided by law, including possible removal or deportation for failure to maintain status, remain in effect. That's all for today's video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video. Till then, take care and stay safe.